Hi, and welcome to the Migrant Know Your Rights video series. My name is Vincent Wong, and I'm a lawyer with the International Human Rights Program at the University of Toronto. Today, we'll be talking about how folks can get permanent residency if they are out of status and living in Canada. First, as a qualifier, this is not legal advice, but rather legal information, and each person's immigration situation is unique and should be discussed with a qualified immigration lawyer or consultant. So let's get started. One common way in which those who are out of status can regularize their status is if they have a strong refugee claim. And to understand if you have a strong refugee claim, there are some elements that refugee claimants need. First is that a refugee claimant has to be outside their host country. Second is that they have to prove a well-founded fear of persecution under certain grounds. These grounds are persecution in your host country, if it's due to race, religion, political actions, your nationality, or membership in a particular social group. And social group does include persecution based on things like your gender identity, or your sexuality. And the third part of it is being unable to receive the protection, or that your country is unable or unwilling to protect you from this persecution. You may also apply, secondly, as a person in need of protection. If you face the danger of torture or risk to your life, or risk of cruel and unusual treatment or punishment if you return home to your home country. For example, in the context of China, members of Falun Gong or unauthorized practitioners of Christianity or land defenders against protests against demolition or ethnic minorities may have claims to either a convention refugee or being a person in need of protection. The rejection rate, however, for refugee claims is quite high. Only about 25%, for example, of total refugee claims from China were accepted in 2019. But again, the situation and the chances of success depend on your particular circumstance. If you are rejected for your refugee claim, you may have the right to appeal to the Refugee Appeal Division. And if that doesn't work, you may have the right to file a judicial review at federal court. If all your refugee appeal options are exhausted, then you may be issued a deportation order for you to have to leave the country. The second common avenue I'm going to talk about is that of spousal sponsorship. So you may be eligible to apply for immigration status if you are the spouse, common law partner, or conjugal partner of a Canadian citizen or permanent resident holder. Common law generally means somebody who has been living in a spousal relationship or a common law relationship with someone, their partner, for at least a year continuously. Conjugal relationship is similar to common law partner, but you have to prove that you were not able to be physically together for reasons out of your control. And the spousal sponsorship category, very importantly, includes same-sex relationships. So it is very possible to have your same-sex partner sponsor you in becoming a permanent resident. One element of eligibility is the sponsor would need to be able to support you financially and ensure that you will not need government social assistance while living as a permanent resident. You will also need to prove that the relationship is both genuine and not primarily for the purposes of immigration. This can be quite difficult sometimes, and you will have to prepare your documentation comprehensively, and answer together with your spouse questions regarding the dates and details of your relationships, as immigration officials are very sensitive to indicators of a bad faith application and will be looking for inconsistencies with regards to details. Some further considerations include children. Children can be a very large factor in the success of your application and whether or not your spousal relationship is seen as genuine by immigration authorities. Your dependent children can also be sponsored for permanent resident status as part of your spousal sponsorship. For spousal sponsorships that are done inside Canada, you also have the option of applying for an open work permit while you are awaiting your processing of spousal sponsorship inside Canada. One important thing to note is that if you are under an official process of removal, for example, if there is a removal order out for you, you cannot do an inland sponsorship according to the regulations. You would need to apply for a humanitarian and compassionate exception to your spousal sponsorship, which we will explain a little bit later on. The third common avenue in which people get permanent resident status is through the humanitarian and compassionate claim, or otherwise known as the H&C claim. Now, this claim is a claim of last resort in that if you are not able to apply for legal status any other way, you may try to apply for being granted an H&C exception to acquire permanent resident status. And in doing so, immigration authorities have to establish whether or not your claim is strong enough and there are strong enough humanitarian and compassionate considerations to allow you to stay in Canada. When they're making this decision, they look at a lot of different things, and we'll talk about some of them here, but the list is potentially very, very long, and anything relevant can and should be considered by immigration authorities. For example, whether or not you have ties and establishment in Canada. So that might include family that you have in Canada, that might include financial ties that you have in Canada, if you have jobs in Canada, volunteer work, community work, education and training. These would all have an impact. Second is that of children. Again, just like spousal sponsorship, having children, either of your own or who you take care of, and the impact of those children on you staying or not being able to stay is a very important determination. Host country conditions are also very important. If there is violence going on or a possibility to persecute somebody like you, then that is something that has to be considered. Or if you will face extreme hardship or harmful consequences if you are forced to leave Canada back to your home country. For example, this can include discrimination if you are a gay or lesbian or trans, if you are a sex worker. These sort of considerations are relevant. Another one is that of health consequences. So if there are medical issues that removal would affect on you, such as if you are having access to very important life-saving medication or treatment in Canada that is not easily procurable back in your home country, this is a relevant consideration. A big one is also that of family. What is the consequence of the separation going to be on your family and relatives, as well as those who face domestic violence in their families, um, and have to get permanent status as a way to stabilize their situation. Victims of domestic violence may have a strong sort of factor when they are trying to argue that they have a humanitarian and compassionate reason to stay. And finally, that it's very important that you show that you can potentially support yourself financially without social assistance in your agency application. And to that end, having a job uh, or running some sort of business that allows you to be self-sufficient could be seen as a positive factor. So those are three of common ways in which those people and migrants who do not have status in Canada may apply for permanent status, or those who have temporary status in Canada may apply for permanent status. We did not talk about economic avenues to migration in this one, um, as this is more focused on those who are out of status and migrant workers who are inside Canada. So hope that was helpful, and we'll see you in the next iteration of this web series.